Well, good afternoon, everyone. Thank you for coming. So I'm absolutely delighted to welcome you to hear our discussion workshop on discrimination and segregation with regard to Roma. I can't think of anybody better to introduce this discussion than Professor Helena Hofmannová from Charles University in Prague. We go back some way. There's a Michigan connection as well, as I've had the pleasure of teaching at Charles as well. So Professor Hofmannová is one of the most distinguished legal academics in the Czech Republic, professor of constitutional law at Charles University, and a member of ECRI. So international and European experience, as well as deep experience in the Czech context. So she's been visiting us for the last few days, and we've been driving her very hard with meetings at the Quality Commission yesterday, the Human Rights Commission, Robbie McVeigh we had lunch with, and then this morning we had a discussion on Section 75 and the implications of that. So if she's not too exhausted by this time, I look forward very much to hearing her. And then we'll speak for about maybe 45 minutes and then have a discussion afterwards. Helena, over to you.
Okay, thank you very much. Thank you very much for a very nice introduction. And also thank you for coming. And I'm really very, very pleased that I have this opportunity to share with you some ideas of my research concerning discrimination and I would need higher and segregation of Roma, more precisely on the effectiveness and role and effectiveness of law. And I focus primarily on the issue of segregation of Roma pupils in education. So what you can expect today, or a kind of structure of, maybe I'm going, oh yeah, structure of our seminar or workshop. So first I will try to introduce some of my starting points and basic ideas of my project, and I will try to demonstrate these both on current and also historical context. And specifically, I would like to focus on the following issues. So kind of special schools and segregation of education. Then on the response of the European Court for Human Rights on the segregation of Roma in education. Also, I would like to tell you something about the very modest, but still some kind of reaction, judicial reaction of the Czech Constitutional Court on case law on segregation of Roma pupil, and then in the next part to think a little bit more about the content of the terms ethnic and racial discrimination and how they are used in the, especially in the interpretation in the case law of both European courts. And also, finally, I would like to make a few remarks on new developments in the court's case law, which represents the requirement of positive measure in this area. I know it sounds like a lot of issues, and they are pretty diverse, but I wasn't sure about the audience, so I tried to prepare some kind of overall picture, what in my opinion are one of the most important legal issues in the area. So first of all, maybe let me start with some facts. I just really make some brief information because we don't have really time for some more concrete facts in member states of the European Union or Council of Europe. But if someone is interested in the discussion, I have also some concrete facts, findings concerning concrete member states. So what we can say that more than half of the European Union member states and more than a third of the Council of Europe countries, segregation of Roma pupils is traditional, long-standing and systemic part of education system. these countries, just for example, include Czech Republic, Slovakia, Hungary, Croatia, but also Greece, Poland, Romania, Portugal, Latvia, Estonia, or Cyprus. This is just few of examples. And in some of these countries, more than 90% of Roma children are placed in special schools with reduced curricula, or they are placed or enrolled to schools with equivalent curriculum, but they are placed in separate classes. But however, when we view to access on education from border perspective, I meant the perspective of the right to education, or we can say right to inclusive education. So I mean that I can say that the situation is problematic in all countries, literally in all countries when Roma live, and this wider perspective includes issues such as dropout rates, or which are very high in all states of Roma, dropout rates of Roma, absence of assistance for children with special needs, or providing culturally responsive education. But without addressing these issues, the right of education cannot be realized, as we are witnessing in Europe concerning Roma pupils. So these facts show that segregation in education is not only a problem affecting just a few countries, few European countries, but it's a Europe-wide problem, and it's also a complex, very complex one. So at the same time, so Europe-wide and very complicated and very complex. So I would like to start with some, oh, I'm going back. With some starting points of my research, because I think it's good for you to understand what was my basic assumptions. So the first of all, I think it's very important to research or to examine the position of Roma in the legal historical context, in their position in Europe. Because the notion of Roma as a second-class citizen has a very long and historical tradition in almost all Europe. So the second is that I think it's necessary to understand the legal status of Roma as a part of the law. As trivial as it can sound, legal scholarship doesn't often approach the research in this way. Another important issue which is connected with this issue, with all these problems and question, is also specific nature of Roma minority, which differs in many basic, I would say, respect from other national or ethnic minorities living in the Europe. Then I would say that these previous assumptions led me to the need to rethink the key concept, or maybe precisely rethink to use of the key concepts of terms such as nationality, nation, ethnicity, ethnical discrimination, ethnical minority, race, racial minority, racial discrimination. And what I should also add, that I deal with this question mainly in the Czech, respectively Czechoslovak context, also international context because of case law of the European Court, but especially I'm focused on Czechoslovak context for, I would say, a number of reasons, not only because it's my home country, but also because this is a country, Czechoslovakia later and then now Czech Republic, where discrimination and segregation of against Roma, including education, not only education, but including education, is a long-standing and structural. At the same time, as you probably all of you are aware of, the case of DH and others versus Czech Republic open up the case law of the European Court for Human Rights in the field of segregation in education, and brought an articulation of the test of indirect discrimination into its case law. There were some cases before, but this was really the main, the pilot case with the formulation of indirect discrimination to the European Court of Human Rights case law. Another reason is the question of the extent in which the position and situation and position of Roma in Czechoslovakia and Czech Republic has been influenced by the specifics of the communistic ideology, communistic, or maybe later we can say socialistic ideology. And also what I would like to stress, and I'm sorry in advance because maybe I will be stressing this more times, but what I would like to stress still in the beginning, that it must be taken into account that segregation in education is just part of a whole complex of discriminatory practices, and as such, just like a part of whole chain of discrimination. This is very connected to the indirect discrimination and structural discrimination. Therefore, I'm stressing this. I hope now it's okay. So, and on the basis of my research up to now, so I have come to two basic assumptions, which I will try to document within the seminar. Firstly, I would say that the position of Roma as Europe's largest transnational minority is characterized by this paradox that in one half there is international and also national commitment by states to reject racial discrimination and to prohibit discrimination, including wide range of international and also constitutional and legal instruments. But on the other hand, we are witnessing the existence of a number of discriminatory practices which are or which have a basis in law. And secondly, if we research this issue, so I think I can say that for the whole history of the modern organization of Europe up to present, actually my research starts in 1980. This is the year of the foundation of the independent Czechoslovakia. So that the whole history of modern organization of Europe up to present, the treatment of Roma has been based on racial grounds, regardless whether ethnic or social criteria are used externally. In other words, we can say that although modern European law rejects race as a biological and genetic determinant in the treatment of people, a racial approach is used in the application, at least in the application at law, sometimes also in the formal norms. We can speak later about some concrete examples. So maybe I should add that I consider racial approach basically as one that treats a certain group of people as inferior or subordinate. And this conception, this notion is based on some genetic, biological features, characteristic of this group, just for the basic like assumptions. And also this is interesting, this approach is consistent with the International Convention on the Elimination of All Forms of Racial Discrimination, which defines, and I'm sorry, I wanted to put this quotation to a slide and I forget, so I will quote this, which defines racial discrimination as any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect nullifying or impairing the recognition, enjoyment, or exercise on equal footing of human rights and fundamental freedoms, etc. So this is for some basic thoughts, and now I would like to start a bit with how to document what I already said. So I start a bit with historical context. So as for the historical context, you consider this is pretty busy slide, so I put it already now. So as for the historical context, I can tell you honestly that until I looked deeper into it, I really had no idea. Even I work with human rights for decades, but I had no idea what a terrible story of law, or maybe more precisely injustice, it is. So since 1918, thus again since the beginning of the modern organization of Europe, the following methods have been and still are being applied to the Roma, all of which are regulated by law. So you can see them. I hope you can read them. Maybe the first one, maybe the better term. I couldn't find the proper English translation term. It's maybe register of of especially of not only of nomadic and traveling Roma population, but all Roma population. So this is, I mean, this is from it has roots much more before the beginning of last century, but this is still. Then different methods of restriction of freedom of movement of residents, like regulation of residents of Roma people, prohibition of nomadism. This was typical method, forcing Roma in different ways to settle, or concrete methods how to immobilize Roma nomads. So they make from their caravans the houses and etc. and etc. So another method which is connected is segregation, not only in education, also in housing and jobs and also education. Then the genocide, and also the refusal then after genocide, the refusal to recognize genocide on the grounds that the Roma were not exterminated as Jews based on the race, but because of their criminality. This was the basic justification for doubtness to recognize genocide on Roma. Then repression, and we can divide. There was a repression as such, just like a clear method when people, it was many times in our history after the wars, both wars, after the Second War again, when they came from the concentration camp. So people just wanted to get, and municipalities, they just wanted to get rid of them. And it was with cooperation of public authorities, because the public authorities were forced to solve the racial violence and other things which were accompanying this kind of repression. And also repression as a more sophisticated method as a part of assimilation techniques. So this is the other typical method was re-education. This was very special in the communistic regimes. Also intervention for public health purposes, including, for example, not only sterilization of Roma women or castration of Roma men, but also forced vaccination, or using DDT. I don't know if you know DDT disinfection in Roma, like forced DDT in Roma settlements. It was very, very common practice in former post-Soviet Union states. Then, you know, it sounds a little bit paradox, and it is like a destruction, extermination of Roma settlements, but on the other hand, establishment of new Roma settlements, new Roma ghettos. You know, it was very, very usual practice in Czechoslovakia. Criminalization, then very different methods of social engineering towards Roma. The other kind of method was the fight against, I use the term which were used in 60s and 70s last century, like gypsyology. It is kind of as this is, I would say it's politically disloyal with the communistic regime, nationalism, gypsyology, and also it includes the refusal to recognize Roma as a national or ethnic minority, and also a refusal to recognize Roma language in, for example, education or other public areas. And then different, all unsuccessful resettlement programs, which meant like displacement of Roma, and always after failure of such resettlement program, there was the return to the social engineering or eugenic methods, and such as sterilization, for example. So this is, and also forced identification, which is very also special, which creates some subcategories of Roma under the category of Roma, depending on their social adaptability, I would say. So this is the basic methods, and as you can see, some of them are still, unfortunately, contemporary. And different approaches. This is, I could make all seminar just about these approaches. So this is just a very brief. I try to give you some very brief view on the approaches. So one of the very known is the racial science approach, which is based on race, as a biological and genetic determinant. Also, it covers different eugenics methods, and it's based on the assumption, and now I quote from some works on these methods. It's based on the assumptions that Roma have backwardness in their blood. This is, I think, very typical characterization of this racial science approach. And this wasn't only in the post-communistic country, it was spread in all the Europe. And what I can tell you that this racial science approach was also used as a tool for political propaganda. And here, in the second example, here lies one of the specific of the politics of totalitarian communistic ideology, because, you know, equality of race and sex after the, and gender after the Second World War, briefly after or just after the Second World War, was one of the Soviet Union's major, not Trump, but Trump cards, in negotiation the Universal Declaration of Human Rights, because the Soviet Union criticized the United States for segregation and Asia for colonialism. And so this was one very big ideology card, and also specific feature of the Soviet concept of equality was the equality which was based on labor, not on liberal ideas of humanity, but on the labor, on the absolute connection to the labor market, to the kind of, and to the ideology and loyalty with the communistic party. So this is the attempt to create a model Roma socialistic citizen. Oh, then we have this very, very, very popular at this time from 50s or maybe late 50s and 60s approach is to treat Roma according to objective indicator of social inadaptability. If I hope I will translate the term, you understand what I mean. And to create, this is the first step, that this is objectivization, that Roma are social inadaptable. And then the law created different categories for them according to their degree of adaptation, such as, you know, and each category has different legal consequences concerning enjoyment of rights, such as backward, adaptable, or most advanced, and others and others. So there are some kind of subcategories. And all these approaches were and are moving in kind of the circle, because from an explicitly racial approach, it was the first one, to a social engineering approach, which was implicitly of racial too. And all, I can say, all these approaches was based on the fact that they treat Roma as a lower class, second class, or inferior citizens. Also, I think I can conclude all these techniques and approaches that that the aim of all these practices, even they were covered formally as a part of the program of assimilation. So the aim of these practices was to exterminate, to get rid of Roma from the concrete country. Okay, so now allow me to go a little bit to the current context, and we can say to the continuing of one of these methods. So now, or in the next session, I would like to speak a little bit more about, in more detail, the segregation Roma in education. So let me just really briefly make some background of the situation in Czech Republic and Czechoslovakia, because I really do not know what you know about the concrete facts. So I will be just really brief. In the Czech Republic and before in the Czechoslovakia, the segregation of Roma, as I already mentioned, and not only in education, as you can see, was a commonly accepted structural part of society and law, and as such it was valued like a very positive, that we know how to educate Roma, which are almost impossible to educate. This was the official, not only justification, but it was also the prevailing notion in society and also among politics. Segregation of Roma in education is legally, based on my current research, is a legally formalized institution from 50s, from the law which was accepted in 52, maybe even later, but I'm not sure now. I need to exercise this mode, but at least at 50s. And the sense or the content of this segregation is that the Roma children were and still are, the system is same, basically automatically placed in so-called special schools, which are designed by law for children with mental disabilities. And the official justification was their culture and linguistic also differences and their inability to be educated. This is very difficult for me to find the word in English. They are like uneducatable, they are taken. So this was the formal and still is formal justification of this law and of the system processed by law. And segregation education is kind of founded of the assumption assumption that Roma children have lower intellectual abilities for education than majority population, and this is formally justified by the results of the psychological tests. So, and these psychological tests, despite maybe we can say the facade of neutrality, they reflect racial prejudices in society. And what's the problem also with special school is that in special school there is a much lower curriculum than in other schools, than in majority schools. And secondly, Roma children are isolated from children from majority population. And as a result of this segregation system, they receive, if they finish, they receive very poor education. They cannot continue in a higher level education with this kind of education. And all this further increases their problems, including problems with housing, employment, and I can say equal life in society. And the segregation of Roma in education became more widely known as a result of the already mentioned judgment of the European Court for Human Rights from 2007. The date is important because we have 2024-5. And I will tell you later what happened after 70 or almost 18 years after the decision. And in this decision, European Court for Human Rights concluded that this official reason for placing Roma children in special schools, which are these educational needs related to low intellectual abilities, cannot be considered a legitimate aim, but a segregatory measure and violation of Article 14 of the Convention, together with the right to education. What I would like to should add, and I already mentioned in the beginning, that however, the segregation of Roma is not really limited only to the Czech Republic or to these few countries that are often referred as the usual suspects, but in this respect, it's really like much more widespread problem. And therefore, I put this slide here because we can analyze two main areas of discrimination against Roma in Europe. The first area is what I was speaking about, mostly the segregation, in the sense that we are separate pupils on the basis of their different origins or different lifestyles than a majority in the separate schools or classes in one school. But the second area is area of unequal access to education. And as you can see, this area covers much more facts, much more processes, much more methods, how to enable equal any sometimes access of Roma for education. The last one, for example, is very important too, because, for example, in Czech Republic, the enrollment of pupils is based on your place of residence, and this was very important how you create this catchment area. So we have these two main areas, and these two areas are very closely interrelated, and I would say that the second leads to the first, or they are really very interconnected. And all these issues were addressed till now by the European Court of Human Rights. So now we can have a look what was the response. It's just again brief because I think you know the case. So, but I think it's good to sum up some information. Okay, so this is the response, the first response of European Court. I will say court, and I mean European Court. So this is, I already mentioned, a landmark case. This was the first decision in this area. The essence, I put some information, but probably you are aware of what information about the facts or essence of the case. It was 18 pupils, which were between 96 and 99. So it's not like in the former regime. It was just after the fall of communism. They were enrolled in these special schools in Ostrava. This is a city in northern Czechia. And this placement was decided by the directors of the special school, who referred to the recommendation of Educational and Psychological Counseling Center. These are statute center established by regions in the Czech Republic. And they are making their recommendation based on above mentioned psychological tests for Roma and also for other kids. And the complainants, they alleged that they had been subjected to discrimination in the exercise of their right to education on the grounds of race and ethnic origin. And they argued that they had been treated less favorably than non-Roma children in a similar situation without objective and reasonable justification, and that this situation constitute indirect discrimination. So it was already in the complaint. And this is a landmark case from several reasons. First of all, the European, as I already mentioned, but this is very important, the European Court in this case, formulated the concept of indirect discrimination, and the content of this concept or definition of indirect discrimination was taken directly from the European Union directives, from the directive on the burden of proof, which is very important in these cases, and from so-called race directive. So this was very important, not only in the area of the segregation of Roma, but especially here it is the mostly developed. Then, secondly, what is also important that the court, for the first time, if I am not wrong, and I may be wrong, but I think it was explicitly for first time, has found a violation of a convention convention right in relation to a case of structural and systemic discrimination in the field of education. So the court therefore found that the convention deals not only with the specific act of discrimination, but also with systematic practices that deny racial or ethnic groups the enjoyment of their convention rights, taking into account not only legal facts of the case, but also court looked also to its social context, which was very important in the case. And regarding the content of indirect discrimination in this case, the indirect discrimination was proven by the fact that the apparently neutral measure was the test, the psychological tests. So this was the neutral measure. Then the complainants, these 18 complainants, have succeeded in proving disadvantage on the basis of statistical data. Therefore, data issue is very important. And this data was on the excessive number of Roma pupils in special school on one hand, and on the contrary, their minimal numbers on mainstream schools. And at the point, the burden of proof shifted to the government, and government failed in its justification on differential treatment, and the court found that the testing of Roma children was not objective, and the results were not evaluated with regard to the specific characteristic of Roma children. So in such circumstances, these tests cannot serve to justify the differential treatment. So this is just some of the case. And so I would say it would seem that the victory, it was big victory, and it was the second decision of DH with DH. The Senate before didn't accept this argument, so it was a really victory. And we can say it would seem that the victory of DH and the introduction, the concept of indirect discrimination could represent a major advance in the fight against Roma segregation. But on the other hand, however, we are back on the paradox I mentioned in the beginning. We are still witnessing that the segregation in education continues and even is getting worse in some countries, including Czech Republic, and not only in the Czech Republic. So why might then that be? You know, why might it be in relation to the court case law or application of the test of indirect discrimination? This is, I think, one of the very interesting and important questions. So I would say, above all, despite the DH success, it's clear what we can see from other cases after DH, that the process of proving indirect discrimination is very difficult. It's a very difficult process, and practically speaking, it can be said that without advocacy groups, Roma could hardly, very hardly initiate and undertake such case. All the cases before the European Court were also initiated by advocacy groups, some different organizations, different NGOs. So this is the first thing, you know. Why it's so complicated? It's also complex. Why it's so complicated to prove, I would say, and I'm trying to prove this in my research. I will show you after a while one of the examples. The courts are unable. I'm now mostly speaking about the Czech Republic, but I think it's much more common. The courts are unable to handle cases of discrimination and indirect discrimination, maybe more, because it's much more difficult. They really find, and there are more research, for example, from my colleague Barbara Havelková, who is dealing with this issue, not relating Roma, but for example, gender equality. The courts are really able to find very complicated, several reasons for formal not acceptation, you know, another ground they don't want to hear. They are fear to hear or to formulate the word discrimination. So this is kind of very typical for the Czech Republic, and I think also for other countries. So the courts are enabled. I will show you example, very, illustrative example a little bit later on. So, also, you know, this is a part of chain which affects the status of Roma, and that cannot be isolated from each other. So therefore, it's very difficult, if not impossible, to prove one specific discriminatory aspect in this area, because the courts are still not accepting this structure or discrimination, or it's sometimes very difficult if there are more grounds which are interconnected. Also, or I would say, secondly, the courts, the victims of, as I already mentioned, of discrimination lack de facto access to law. So when I mentioned that it's hard for Roma to initiate such case, such proceeding, this is even another much more difficult issue, because Roma legally, yes, formally, but practically they do not have access to law. This is a very also complex issue. The proceedings, as you know, are very long, very expensive. So it's even very difficult to find an NGO or advocacy group. And then the issue, I made some investigations and questionnaire. So these groups and attorneys who are willing to represent Roma, they think they found a common opinion what would help, what would be necessary. It's some money. It's some money how to pay them to handle the cases, you know, to support them, because, you know, no one, there is no one who could pay this, because Roma cannot pay such proceeding, and also the NGOs, for them it's very difficult in Czech Republic to find a sponsor or some project for this. So this is also a very practical problem. Then another problem, which is more theoretical, but also with a big practical impact, is inconsistent approach of European courts, because European courts do not, even the European Court in Strasbourg, still the indirect discrimination from Court of Justice. They do not have same application of these two forms, like direct and indirect discrimination, and for proving this. And these aspects are essential in cases of segregation of Roma in education, because indirect discrimination, of course, is harder or more difficult to prove than direct discrimination, and thus provides, I can say, less protection or difficult protection for the victims. And related to this is also the question of the enforcement of the court judgment, of the court case law, including the age. And this is interconnected with the issue of the more complex impact of such decision on the situation of Roma in the concrete country. So I can finish this part by saying that to this day, the Czech Republic has failed to remedy the situation. We are still, for almost 17 years, we are under the strictest execution of the judgment through the supervision of Committee of Ministers of the Council of Europe. And also another fact is the European Commission has launched this infringement procedure. So since I can tell you that this end, in fact, in reality, the discrimination and segregation of Roma children in schools still persist. And the last numbers, last facts from the reports from last year shows that it's even worse, that the number of segregated kids it's bigger than it was in the time of DH case. So at this point, I thought it can be interesting, the reaction of the Constitutional Court of the Czech Republic, but first I need to drink a bit. So this is the reaction of the Czech Constitutional Court. Actually, it's very, very difficult to find the cases. In the Czech Republic, we have database only concerning Constitutional Court and Highest Court, Supreme and Highest Court. We do not have any database of other ordinary lower courts. So I'm just working on this also to find some other, if there were any, because as I told to Chris, for example, in 5 years, in all country, you have, based on the data of public defender or ombudsman, in 5 years, we have overall about only 90 anti-discrimination complaints, 4 of which were successful. So it also says something. So there is only one decision after the age, post-DH decision, as I call it, of the Constitutional Court. And this decision is kind of unbelievable because, you know, this is another case. You have if you want to see the case, this is 2 years. The decision lasted 2 years. And this is the decision also concerning alleged indirect discrimination against Roma children caused their placement in this special school. The facts are very similar. It's almost identical like in DH case. And the court first found in 2015, after DH, you know, he found that, I quote, the purpose of the special schools is not to restrict access to education for Roma children, but to enable their education due to their intellectual deficiencies, which do not allow them to complete mainstream education. So this is the official reasoning of the court. And the Constitutional Court practically, in this practical part of reasoning, found that in this present case, it was not necessary to apply the conclusion of the decision in the age, since in this case, the applicant's intellectual abilities had been evaluated continually during his studies, and his placement to the segregated school was not routine or formal. And it's worth noting what I put like quotation to the slide. So if you can go through, this is something, you know, which shows us, I mean, especially the last part, that it's this conclusion can be made despite the fact, in the context of the facts, in particular the existence of racial prejudice, created room of segregational practice. So, I mean, we can conclude that from this is clear that the Constitutional Court has completely misunderstood the nature of segregation, the danger of segregation, the context of segregation, and also the context and sense of the indirect discrimination. So this is only judicial reaction of the Constitutional Court, who didn't use the potential of DH case. And in contrary, I think it's total misunderstanding because, you know, the court says it's formally it's okay, even it's a kind of segregatory practice in the segregatory environment. So this is the judicial reaction. And I think this is connected with this second or next issue. What's going on here? Is it ethnic or racial discrimination? Because we were speaking this week more times about this, because I was surprised in some meetings that people from NGO, they use term racial groups, and this is something which we don't use in the Czech Republic, because formally it's something people are afraid to use it because of the, you know, the Holocaust and all our history. So I was surprised, but this is very, I think, important in the sense of impacts of the use in law, this term, not formally. So, and this is, you know, so I think we know all, I'm sure all of us know that the concept of race, like the idea that humans are divided into groups of different qualities, based on the inherited psychological or behavioral differences, has long been discredited, and it's not possible in law. And also current law or interpretation of current law considers formally ethnicity, race, also minorities, as a social or culture or social and culture, not biological construct. This is, I think, obvious. But however, I would say understanding race and also ethnicity as a social construct or stereotype creates difficulties in a legal interpretation. You know, how you can interpret the social. It's very difficult. Stereotypes and prejudices are very difficult to interpret in law. And I put here one thought from the, you know, I put it. This is the report of the European Network of Legal Experts on the meaning of racial or ethnic origin in European Union law. It's very complex, and there is also comparison in the notion in member states. And I think this is very important because the report showed that rather than classifying minorities as national, ethnic, and there are the list, this example, the ways in which less favorable treatment can be demonstrated are important. And this is the notion of the report in the introduction, which I think it's very important. And the report showed that the long-lasting quest for identifying differences between racial and ethnic origin has been futile, and the report urged the legal profession to refrain from further pursuing such endeavors. And this search also, they also say that this search for these differences obscure the fact that in Europe, national origin is an essential part of the composite category of origin, while at the same time creating interpretation of racial origin as reducible to skin color or psychical appearance. So this is kind of, for me, important conclusion that the way the impact in law is important. So also the issue of ethnic discrimination and the content and meaning of ethnic discrimination was also addressed by Chris McCradden, if I'm not wrong, in his article commenting another decision, not the decision of European Court for Human Rights, but this is the decision of European Court of Justice in the case of Nikolova. So it's a little bit another context at all, but his comment points out that it is important how the term ethnic discrimination is used. And I don't know if no. So Chris pointed that, and why I found it important, that one of the recurring issues that arises in the concept of ethnic discrimination is what is meant by the term ethnic and which context the term applies. And you mentioned very important point of view that this issue is particularly acute where, as in several European states, there is a considerable unease regarding racial categories which are seen as dangerously close, accepting to the long discredited myth that is the scientific basic for racial differences. And in such context, the use of the ethnic criterion seems less controversial because it doesn't have the chained association of racial categories. This is very important and very proper comment on the use of term ethnic, because I think not only like interpretations like academics, but also courts use ethnic just because it's better. It's not controversial than to use another term, like, for example, even national can be controversial, but race is very controversial. So, so this is one important thing. The second is still a lot of misunderstanding between the differences between the nationality, because in my country we take nationality as a subjective, totally subjective criterion based on self-identification. And contrary to that, ethnicity we supposed to be as an objective category based on this different language characteristic, color of skin, country of origin, and etc. But you can find a very different notion and definition of all these terms. This is just some thoughts, but the European Court, oh, this is the new stage. I'm sorry, I don't have so many slides. But the European Courts for Human Rights, I would say, has not commented on these two concepts, but only stated in general terms, I quote, that discrimination based on a person's ethnic origin is a form of racial discrimination. So this was the comment of the European Court. But what, again, I think is important from a legal perspective is specific implication of the use of term race or ethnicity for the status, for the position of people. And if we take a closer look at the case of DH, but also to other cases after DH, cases concerning segregation of Roma, we can see that governments use and also the law and governments for justification then use as the basic argument for the objective justification of the treatment of the exclusion of Roma, they use the specific educational needs related to their low intellectual abilities or uneducatability. This is the official term. So the Council of, so this is the official formulation. The Council of Europe Commissioner for Human Rights in DH, for example, stated that the real criterion for segregation of Roma is ethnicity, while the Advisory Committee for the Framework Convention stated that the children who are not mentally disabled are placed in special schools because of linguistic or cultural differences from the majority population. So, you know, it creates a question, is segregation on education based on ethnicity or race? And this is not an easy question, but in fact, if we have a closer look to the decision and reasoning of the European Court for Human Rights, we see that the placement of Roma children in special school is based on the assumptions that their specific, and now I quote the terms, specific educational needs are related to their low intellectual abilities, not on the assumptions that their specific educational needs are related to their cultural and ethnic characteristics, which is very different two notions. And on the contrary, the culture and ethnic specific of Roma pupils were not reflected in their testing, and tests reflected racial prejudices in society. And this was the main argument for which the European Court found this test to be a measure that could not serve to justify differential treatment. So even the court, you know, first of all, uses these terms inconsistently, and secondly, he borrow and work with this racial notion to Roma pupils as is in the governmental formal justification. And finally, the last thing which I would like to stress today, which I think it's very important, is to say something about really revolutionary almost big development, big shift in the case law of the European Court of Human Rights after DH, because there is a big shift, big change in the case law. I think it is connected with the fact that segregation is ongoing. I think it is connected. It's kind of reaction on the fact. And I think it's a really significant change. So, and this new development is based on the, as you can see, on the shift that the court moved or is moving from examining what he was doing this till now. He was examining the existence of legitimate aim of alleged discriminatory treating. But now the court shifted from examining the existence of a legitimate aim of this alleged discriminatory measure to examining the legitimate aim not adopting positive measures, which is something very, very different. We can even say that this shift from a focus on segregation on education to a broader notion, which I mentioned in the beginning, to a broader notion of the right to inclusive education, because, you know, it includes a lot of positive measures in this area. So it can be traced from Oršuš case, Oršuš and others versus Croatia. So it was a case concerning Croatia, and there was the main justification was different than ADH. It was language, the knowledge of or absence of the knowledge of Croatian language for Roma kids. And also the case is significant and different because there wasn't possible to use the statistical data. It was the different method of proof, like the social context, and also maybe therefore there was possible to formulate these positive measures in this case. So we can trace this shift, which lasted till today, even already from Orshu's case. I mean, the second decision of the Grand Chamber. It was a little bit similar history, but like with DH. So second Grand Chamber decision, and here the court articulated specific, very concrete positive measures that the state should have taken, and the court evaluated their non-adoption as a violation of the prohibition of discrimination in connection with the right of education. So, unlike, for example, DH or before Sampanis case, Sampanis versus Greece, where court referred only to the more general and vaguer term special measures, in Orshu's court established a really clear obligation of the state, in this case Croatian state, on the part, especially on the part of social services, to implement positive measures in order to assist applicants, with their difficulties in education. And this could be considered as a groundbreaking change. It's really, in my opinion, a very big change in the court's approach. And I think I should say it in advance that I think it's a direction, or it's a principle, or I mean, it's in principle development in a good direction, but it has a number of challenges, number of doubtness that I think need to be addressed. And and there are some of them, some of the challenges. So first of all, there is the basic question, basic legal question, or very question whether the European Court for Human Rights can address, you say no, okay, address or impose the positive measure, which is very complex and very complicated. If it's not, you can read a lot of comments and papers that it's not like kind of overstepping its mandate, or that the court takes a role of rulemaker, which is contrary of the principle of state margin of appreciation, because in Orshush, I don't know if you are familiar with Orshush, but the recommendation, the positive measures are very concrete concerning textbooks, and monitoring process. So this is first challenge, The second challenge, what I think it's what the level of the design of formulation of positive measures, because how to formulate them in concrete terms, so that they are both of real relevance for the case and they are enough specific for the concrete situation, because each case is very different, and at the same time applicable as a precedent for other similar cases. This also can cause a lot of problems. And again, as we saw in Orshush, the court has defined quite specific positive measures. And the third issue is what will be, what will be next? Will the court follow, and did follow, the same specific approach in other cases, like with Albania, X versus Albania, or Moldova, that we have more cases. So, and the comparison is very interesting, because almost in all next cases, they are again back very general, like this fact term special measures, or there is the very popular method of argumentation, just repeating what already been said. So, you can read in Albania the same like in Orshush in Croatia, but there was not language problem. There was another with the food assistant problem. So this is also very, very difficult question. And however, there is another very important question in this context, and this is the context or the question of ad hoc, what we can see from this ad hoc nature of court's decision, which means that only those Roma who succeeded in the court can invoke these positive measures. And here are again back in the beginning, in the heart of complexity of the issue, since access to law is one of the most serious problem in the relation to Roma, because if their rights are violated, they do not have de facto access how to protect them. And I put one very provocative last question, because this is even the question: can European Court abolish special schools at all? Because I think it's not really the better idea to do it in the Czech Republic, because I'm an inclusive person. I think it's very good to include kids. And we have very, very rooted and very developed the system of special schooling, which in basics, it divides all kids, even mentally handicapped and other, kids. I'm not sure, this is my opinion, about the reason, the good, that it's good thing at all, even not based on the ethnic or racist ground. So because this positive measures, or it seems to that he's abolishing kind of special schooling. So these are some questions which are I think are very important. And I'm in the conclusion. I am in the conclusion now, which I didn't even prepare a slide, because I realized I'm not able to make at this stage any conclusions, and maybe I will not be able to make them even when I finish my research, because it's very, very complex, and I don't even know if I want to make them, because I'm not, if I am capable to make them, because I am capable to make this research as a lawyer, not as a social worker or social, and this is really very complex. But I just prepare few thoughts, because Chris McCradden in the beginning of my, thank you, great stay here in Belfast, asked me if I'm optimistic. I am generally. I think I am optimistic person with everything, really. And my life proved that it's good approach. But in this respect, it's a very difficult question. And as you remember, I wasn't able to answer you fluently. So this is very difficult to say, because I would say that given the scale and complexity and long term of the problem, I think that and the toothlessness of the existing legal instrument, for example, in the Czech Republic, and applying them, I believe that the essential is that states really adopt new or appropriate policies, approaches in the form of political and also legal change. This is both necessary, and that this has to be done even at the cost of not having the support of majority of society, which is very politically difficult, and it doesn't have any support in the Czech society. So, and I think, but that indeed, for example, the historical example from US show us that this is maybe the only possible way, to impose this, to the society. And because segregation and institutional discrimination are deeply rooted in social and legal structures, and therefore, if state want to be serious about its effort to eliminate at least segregation, it must adopt an effective, policy, which must really be imposed to society. I think that without this approach, segregation will not, I'm not optimistic, maybe, will not be eliminated within the next 10 years. And indeed, all countries I mentioned, I told you I have another data from Germany, France, Great Britain, Portugal, Spain, Italy, Romania. Ask me, I have really all data because I work in ECRI. So all these countries, because they are members of European Union, they are at least members of, not at least, but they are members of Council of Europe, all of them, 64 states, So they have all possible legal instruments, and also they have these commitments to the international obligation to guarantee equality, to prevent, maybe even I can say, discrimination. So the problem lies everywhere. The problems really lie in this gray zone of the actual implementation from different legal and political bodies. What I think the last, what I would like to mention, that what is also important, and therefore I was so very happy to see just a part, but this today's workshop with equality, with the NGOs, because this is something which we are missing in the Czech Republic. So I think it's essential to communicate, not to go to consistently and to very patiently communicate with Roma community. This is something which is also because they are not represented in the Czech Republic at all. They do not have any political representation. They have few NGOs, but this is not kind of consistent work, you know, so you don't even know to whom you should speak, for example, who represent different groups and etc., which is connected with the very special character of Roma minority, which is very diverse, sometimes based on families differences. So it's necessary, it's essential to communicate problems consistently with the Roma community over a really long term, as well as the same time to communicate these impacts or this problem externally to the majority. And it really needs very long, very patient and consistent approach. And if I start to speak in academy about this, just about that I'm researching discrimination and segregation of Roma, or if I say this, the argument against is often like, oh, it was made everything possible, you know, Roma, you are uneducatable, you cannot deal, come to live in our quarter, you will see how they behave, and you know, it's impossible. And if there are some optimistic remarks, they say, it would be very expensive and it would the process would be very long, you know, so people like give up. And what my answer might be is that even if the way to finding a solution takes more than 100 years, it will not be longer than the time the discrimination against Roma had been going on. So I think we have time and we need to give time, you know, and we should do this. Okay, so I don't know how long it was, maybe longer? No.
Plenty of time.
Okay, thank you very much.